It's a good thing that readers of the Employer Handbook like this vlogging thing that I started doing, because I just got finished reading, earlier today I got finished reading 124 pages of Department of Labor regulations supporting the Families First Coronavirus Response Act, and I don't have it in me to write anymore today. So what I thought I'd do instead is, out of those 124 pages, so you don't have to read them, I'm going to digest them into the parts that I thought were up for grabs heading into today. So I'm going to focus on not the obvious issues, like we know the 6 reasons why you can take leave to get paid sick leave, although I'm still not sure what reason number 6 means, the one about the Secretary of the Treasury working with the Department of Health and Human Services and all that kind of stuff. No, but a lot of stuff is fairly obvious. We know the answers to that. But today in this video, I want to focus on some of the pieces of the regulations that square up and resolve issues that were a little bit up in the air or confusing going into today. And I'm going to follow all of this up on Friday with a chat on Facebook Live. I will drop links and information in the comments down below, so be sure to subscribe to the channel, like, comment. I'd love to hear from you. And remember, everything that I'm telling you today, as always, is not legal advice, is not meant to be attorney-client privileged. It's just answering hypothetical questions, all right? If you need a lawyer, go find a lawyer and pay that lawyer. I'm here giving free, non-legal advice, all right? So here's what I take away from the guidance, or not the guidance, the rule that the Department of Labor issued today. The first thing I want to start out with is something that has nothing to do really directly with FMLA or paid sick leave. Well, maybe tangentially. It's something under the Fair Labor Standards Act. And the Department of Labor pointed out in its temporary rule today that an employer is not required to compensate employees for unreported hours worked while teleworking for COVID-19 related reasons unless the employer knew or should have known about such telework. So, takeaway here is make sure that your employees are properly tracking their hours, that you have a tracking system in place for non-exempt employees who are teleworking so that they can get paid and you know exactly how much you have to pay them. And they should have to alert you before they work overtime, things like that. So that's the first thing that I took away from today's temporary rule. There's another FLSA point that's in there that I think is important, and that is nothing in the Families First Coronavirus Response Act should be construed as impacting an employee's exempt status under the Fair Labor Standards Act. So, for example, an employee's use of intermittent leave, we'll talk a little bit more about intermittent leave in a bit, combined with either paid sick leave or expanded family medical leave, should not be construed as undermining the employee's salary basis for purposes of the Fair Labor Standards Act. I know we're starting out a little bit wonky here, but these are some important points that you need to consider. Okay, so now I want to get into a little bit of clarification on some of the reasons that employees can take paid sick leave under the Families First Coronavirus Response Act. So the first one has to do with federal, state, or local quarantine or isolation order. What the heck is that, right? So is a shelter-in-place order, does that qualify as an isolation order, a quarantine order, a stay healthy, stay at home? I mean, you're not really tethered to your house. You can go out, you can go to the grocery store, you can get medical help, you can run around the block and get some exercise. Well, the Department of Labor did confirm in its temporary rule today that quarantine or isolation orders include the broad range of governmental orders advising some or all citizens to shelter in place or stay at home, quarantine, or otherwise restrict their own mobility. However, here's the thing. An employee subject to one of these orders may not take paid sick leave if the employer does not have work for the employee to perform. So if the business is shut down, there's no telework available, then the employee doesn't get paid sick leave. Similarly, if there is work available and the employee is able to telework, then just because there's a quarantine order, the employee still doesn't get paid sick leave because they're able to telework. So let's skip to the second reason that employees can take paid sick leave, and that's where an employee is advised by a healthcare provider to self-quarantine. That includes, and the Department of Labor clarified this today, that includes advice to self-quarantine because he or she, the employee, is particularly vulnerable to COVID-19. That person is eligible for paid sick leave if he or she is unable to telework because of that particular vulnerability. So I'm thinking people who are older, maybe age, could make you especially susceptible. Pregnancy, someone with a disability. I've dealt with that in my private practice with clients, answering questions about how does disability interplay with paid sick leave. So if you're particularly vulnerable, as determined by a healthcare provider, and you can't telework and there's work for you to otherwise perform, then those folks can collect paid sick leave. Now, the ability to telework, what does that mean? The ability to telework is based on whether the employer has work for the employee to perform, the employer permits the employee to perform that work from a remote location, and there are no extenuating circumstances that would prevent the employee from performing the work. That is what the ability to telework means. Okay? Skipping down to the third reason that someone can take paid sick leave. We're talking about where someone is going to seek a medical diagnosis because he or she is experiencing symptoms of COVID-19. You can get paid sick leave, but only for the time that you are unable to work because you're taking affirmative steps to obtain a medical diagnosis. So, for example, an employee who is waiting for the results of a test may be able to telework and therefore would not be entitled to paid sick leave. Conversely, someone who is literally being examined by the doctor, sitting in the waiting room, that kind of stuff, they're not able to telework. And they would be able to collect paid sick leave, assuming there's work available for them to perform. The fourth reason the fourth way that someone could collect paid sick leave is if they are caring for someone. The statute refers to caring for an individual. You're eligible for paid sick leave where an employee is unable to work because he or she needs to care for an individual. But who is that individual? The DOL confirmed today that the individual must be an immediate family member, a roommate, or a similar person with whom the employee has a relationship that creates an expectation that the employee would care for the person if he or she self-quarantined or was quarantined. So, does that mean the neighbor around the corner? Probably not, but someone with whom you have a close relationship with. Obviously a family member, maybe an uncle, an aunt, a grandparent, someone like that. You may be eligible to take paid sick leave. The next topic I wanted to get into, and this is going to get a little bit wonky, so you may want to refer to the to the regulation itself. And if you need a link, I'll have links. I'll drop links down below in the comments, and I'll also have links in today's blog post. Calculating paid sick leave for part-time employees. Get ready. A part-time employee whose weekly work schedule varies should be entitled to paid sick leave equal to 14 times the average number of hours that the employee was scheduled to work per calendar day over the 6-month period ending on the date on which the employee takes paid sick leave, including hours for which the employee took leave of any type. There are different rules for a part-time employee with a varying schedule who has been employed for fewer than 6 months. That person's entitled to 14 times the expected number of hours that the employee and employer agreed at the time of hiring that the employee would work on average each calendar day. And if there is no agreement, that part-time employee is entitled to up to the number of hours of paid sick leave equal to 14 times the average number of hours per calendar day that the employee was scheduled to work over the entire period of employment, including hours for which the employee took leave of any type. An employer may also use twice the number of hours that an employee was scheduled to work per work week, on average over the 6-month period. That's a lot to swallow. I'm not going to repeat it. That's one where you probably want to dig into the regulations and read it again for yourself. Moving on. Enough with the part-time work. To ensure consistency among employees with different work schedules, the unpaid period for expanded FMLA, that first 2 weeks or 10 days, which is it? 10 weeks, 2 days, 2 weeks, 10 days, 2 weeks. Is it 10 days? It lasts for 2 weeks rather than 10 days. So the unpaid period for expanded FMLA, that's that reason number 5 for taking paid sick leave when a son or daughter's school is closed and they have no one else to care for them, or child care is closed and the employee is the principal care provider. That unpaid period lasts for 2 weeks, not just 10 days. Because depending on how the employee's work is scheduled, like maybe someone works 3 days a week, 12 hours a day versus someone who works 6 days a week, 6 hours a day, the calculation gets a little bit screwed up. So that's why the DOL decided, let's just go with 2 weeks. The regular rate used to determine the amount of pay under paid sick leave and expanded FMLA should be representative of the employee's regular rate from week to week. So therefore, an employer should use an average of the employee's regular rate over multiple work weeks over a 6-month period, or less if the employee has not worked for the company for 6 months. This average would be weighted by the number of hours worked each work week. Okay. A lot of questions I've been getting from smaller employers, clients and non-clients, is when will the Secretary of Labor exempt smaller private employers with fewer than 50 employees from having to comply with the paid sick leave and expanded family medical leave provisions of the Act? And we talked about this a little bit earlier, and I want to reemphasize it here. This is limited to situations in which the employee needs leave to care for his or her child whose school or place of care is closed or child care provider is unavailable, when such leave would jeopardize the viability of the business as a going concern. And I've talked about the criteria for how you document when the taking of leave in that situation would jeopardize the business as a going concern. So I'm not going to repeat that here. I don't want to make this an overly long blog post, but again, I'll drop links in the comments down below so you can check that out for yourself. It is in the regulations. And pro tip, when you download the regulations and open them up in Adobe Acrobat, open up the bookmarks, okay? And you'll see in the bookmarks that it's divided up by section of the regulation. So it's not as imposing, it's not as overwhelming. You can go to each little bookmark to see the different sections of the Department of Labor temporary rule. Okay, where was I? Oh, I was on intermittent leave. I've talked about this before, but it bears repeating. That there is a basic condition to all potential intermittent leave under the FFCRA. And that condition is that the employer must agree to permit the employee to work on an intermittent leave basis. If the employer decides we're not going to have it, then there is no intermittent leave. If the employer and employee can reach an agreement, that agreement should include an agreement on the increments of time in which intermittent leave may be taken. Okay? If the two sides can't reach an agreement on that, then intermittent leave cannot be taken. Okay? And intermittent leave is limited to particular situations, usually involving telework, and also for the care of, for that reason number 5, care of a child who is home from school. If you're able to work, okay, if you're able to go into the workplace, you can't get intermittent leave for, let's say, reason number 1, because there's a quarantine, or reason number 2, because you have coronavirus. That would be at odds with trying to keep a healthy workplace. Like, we don't want people going back and forth if they have coronavirus. If you can telework, then there are more intermittent leave options. But if you have to go to the workplace, your intermittent leave options are much fewer. In fact, they're only limited to the one where you're caring for a child that is home from school or who has no child care. Now let's talk about the substitution of paid leave. Neither the employer nor employee may require the substitution of accrued paid leave during the final 10 weeks of expanded FMLA. However, the two sides may agree, where federal or state law permits, to have accrued paid leave supplement the 2/3 pay under the expanded FMLA that an employee is entitled to, up to $200 per day, so that the employer receives the full amount of their normal pay, okay? But that has to be an agreement between employer and employee. Additionally, or I should say however, an eligible employee may elect to use, or an employer may require that an employee use, expanded FMLA concurrently with any leave offered under the employer's policies. So we're not talking about a substitution, we're talking about concurrent use. Expanded FMLA concurrently with any leave offered under the employer's policies that would be available for the employee to take to care for his or her child, such as vacation or personal leave or paid time off. The employer must pay the employee the full day's pay for each day. And you're not going to be able to get a tax credit on anything that goes above and beyond the $200 per day that is available for the expanded FMLA. So think about that if you're the employer. There are different notice requirements under the expanded FMLA than there are under the regular FMLA. Let's talk about that for a bit. The regulations do not require employers to respond to employees who request or use expanded FMLA leave with notices of eligibility, rights and responsibilities, or written designations that leave use counts against employees' Family Medical Leave Act allowances. All right, full stop there. So we don't have to use the notice of eligibility. We don't have the rights and responsibilities or other typical trappings of a classic FMLA situation. However, all right, by now, hopefully, you have in place an FFCRA policy. By now, you should have in place an FFCRA leave request form that has in it the documentation, or at least request for the documentation that the IRS wants to see in order to be able to get those tax credits. So while you may not need the classic FMLA notices, you should have good documentation, good policies and procedures, and good paperwork, okay, in order to track employee leave under the FFCRA. If you don't, I've prepared this for my clients. If you don't have it, talk to your lawyer about getting it, okay? For leave taken under the original classic FMLA for an employee's own serious health condition related to COVID-19, or to care for the employee's spouse, son, daughter, or parent with a serious health condition related to COVID-19, the normal FMLA certification requirements do still apply, okay? And like I said, documentation is so important here. An employer is required to retain all documentation relating to FFCRA leave for 4 years. 4 years, all right? Regardless of whether leave was granted or denied. If an employee provides oral statements, you should insist on documentation, but if you get oral statements from an employee to support his or her request for paid sick leave or expanded FMLA leave, the employer must document and retain that information for 4 years. So remember, the employee gives notice of leave as soon as is practicable, is when it's foreseeable. And if it's not foreseeable, again, it's as soon as is practicable. There may be situations, dire situations, where you can't get the paperwork filled out right away. Do your best to document that oral conversation. Again, this is for your own purposes, and also for the IRS, so you can get that tax credit. If an employer denies an employee's request for leave under the small business exemption that we talked about earlier, the employer must document its authorized officer's determination as to why, and must retain that documentation for 4 years. And finally, I'm going to close with this. If you think you have time to prepare with all these new rules or clarification of rules, the FFCRA went into effect yesterday. April 1st. Hopefully you're watching this video on April 2nd, otherwise that could be a little confusing. So April 1st goes into effect. The Department of Labor's temporary rule that came out on April 1st also takes effect immediately. There is no comment period. There is no 30-day delay. We're rolling. All right? If you have questions, if you have comments, drop them down below. Again, I can't give legal advice. I don't want to create an attorney-client privilege, but we're having a Facebook Live chat session tomorrow. So if you lob in some hypothetical questions, I'll give you some answers to those questions that you're asking for a friend, or at least I'll try. All right? Thanks a lot, folks, for tuning in, and I'll see you tomorrow at the Facebook Live chat. Bye.